The case of Robert Allen, Utah Supreme Court, was decided in 1986 by 3 judges concurring and 2 judges dissenting. That is a workers' compensation case. It is often cited as the Allen test for worker compensation in the state of Utah. The main issues in the case are the pre-existing condition and the definition of what is an accident, what constitutes an accident. The plaintiff was Robert Allen and the defendant was the Industrial Commission. The claimant exhausted his relief in the administrative avenue. They resorted to the Court of Appeal, asking the Court of Appeal to review the decision of the administrative law judge, denying him compensation for back injuries, sustaining back injuries at work. The administrative decision was reversed and remanded. The claimant was 36-year-old, working at night as a manager in Kent's Foods. He was working in a cooler. He testified that he was moving 4 or 6 gallons of milk in crates, putting them on the shelves when he suddenly incurred severe back injury. He was able to complete the shift and ask somebody else to finish his job. He went to the doctor, Dr. Evan Wright. He was treated with rest and some kind of traction in the hospital. Back injuries are common in people, but the problem in this young man that he has a history before of lifting sandbags when he was in the Logan District School, and he fell. At that time he was at the age of 14. Now he is 36. In this accident, when he was 14, he broke his coccyx, so he has a prior injury. In this case, when he got injured in 1982, the report of the doctors explained that he has back injuries, but they don't know exactly what happened at the cooler when he was working at Kent. The back injury developed into a left groin pain and some kind of sciatica that affect his toes, a pinching of sciatic nerve, and he had now some kind of pain in his leg. He filed for worker compensation in November 1982. Remember, it took about 4 years to get to the Supreme Court. So the administrative law judge found that the injury, the back injury, was not related to work. So in other ways, the judge said he already had injuries before. He got injured before when he was young. So his injury at work cannot be related to the work. And that is where the Supreme Court reversed. And the argument was that even though he has pre-existing condition, he still was aggravated or caused to have another lighting up of his condition because he was lifting crates of milk. This case will try to address whether the work imposed extraordinary and unusual exertion that is beyond what people do in normal life. The dissenting judges will argue about what constitutes a normal life. We don't know what normal people do in their life. So the sole issue in this case was the appeal is whether the claimant who has pre-existing problem, injured at work of an exertion usual and typical of his job, of lifting crates of milk. The question was that, is that lifting extraordinary and unusual and can cause a person, whether he has pre-existing condition or not, to incur an accident or injury during employment. In other words, the question has 2 sides. The legal side, whether the employment caused him to have an injury, and the other side is the medical side, whether the nature of his work is related medically to the kind of injury he has, the lifting and the load-bearing joints, which are the back. The definition of and by accident will be the emphasis of this case. What is the definition of an accident? The case discusses two prerequisites for finding compensable injury. The first prerequisite has to be by accident, whether the accident is something unpredictable, something that was not intended. Is the accident means something, a point in time, or the accident means a cumulative effect, a repeated effect, like an exertion that takes so long and it culminated into a climax, got injured, whether the person remembers the exact time and the location and the causes of the accident that caused the injury. The term by accident is not defined in the worker compensation statute. They will go back as far as 1992 in the case of Tintic Milling Company versus Industrial Commission to define the definition of an accident. In page 3, an accident connotes an anticipated unintended occurrence different from what would normally be expected to occur in usual course of events. Here is the biggest problem here. What is normal and what is usual? The usual and the normal makes the law complicated, and that will make two judges dissent. When you deal with a worker that have pre-existing condition, did the pre-existing condition cause him to suffer, or the work, the nature of the work caused him to suffer, and whether it is incremental or progressive. Incremental means you have accident after accident after accident, that is cumulative trauma, or whether it is progressive, that is does not have a specific nature of accident, that will be industrial disease. How to define what is usual and normal, and how did the employment created an unusual and abnormal situation. The purpose is to define what is compensable accident. Then in part of the definition of the unexpectedness of the accident, what is an accident and what is ordinary duties, nothing more is required than the harm that the plaintiff has suffered shall be unexpected. In other way, whether the effort was excessive or unusual, or the event was unexpected, the injury or the harm itself was unexpected. This court concluded that there is nothing in the statute which would justify a holding that an injury is compensable where overexertion is shown, but is not compensable where only ordinary exertion is shown. Here is the main issue. How do you define overexertion versus ordinary exertion? Nobody knows what is the difference between overexertion and ordinary exertion. If an employee intentionally and knowingly undertakes to lift an unusual load, the cause, the lifting, is no more accidental if he deliberately lifted a normal load. In this case, the court will create a new standard for causation. Causation for a person who does not have pre-existing condition, and a proof of causation for a person who does have pre-existing condition. How do you exclude the fact that a pre-existing condition is not the cause and the work imposed extraordinary burden on the employee? The second element of compensable accident requires the proof of causation connection. This is the legal part between the injury and the worker employment duty. How do you relate the internal failure of organs to the employment duties, and whether the employment duties are caused, aggravated, or exacerbated the internal failure of the employee's organs or part of the body. So the causal connection in internal failure require us to prove that there is unusual event or activity precipitated the injury. The word unusual and ordinary will create problems. Like any argument, how do you settle what is usual, what is not, what is normal, and what is not. The court will try to refine usual and unusual exertion and overexertion, ordinary and extraordinary exertion measured by the individual involved or by the industrial function performed by him or both. And as we discussed, the legal cause, whether the injury arose out of the course of employment, is difficult to determine, where the employee brings to workplace a personal element, which is the pre-existing condition. That is the final conclusion. The decision of the commission is vacated and remanded because Judge Dorman and Judge Howe and Judge Zimmerman concurred. You have 3 judges concurring, and the Supreme Court of Utah has 5 judges. We have Judge Hall concurring in some and dissenting in some. And the argument of Judge Hall, we already discussed it before, on what is usual and normal and what is ordinary. Then we have another judge dissenting. So we have 2 judges dissenting and 3 judges concurring. Now we have our case that we are presenting here deals with what is ordinary, what is extraordinary, and the legal test of Allen, the connection of the injury to the duty, employment duty, and the medical test cause of injury.
Google Meet. Enter the meeting pin followed by the pound key.
Hello, David's here. Oh,
yeah, he's on.
all right. I see you sent me an email, so let me see if I can link in with that. Thank you. Let's see.
Right, it's a meet.google.com and then slash some random letters. So.
Yeah. Yeah, usually it's highlighted and I just click on it and it comes up, but
yeah, I think you're going to have to copy and paste it most likely into a browser. You can do that.
Well, I can try.
Welcome, Mr. Orgel, and I hope that you're on as well.
Yeah,
I think he's having trouble getting into the Google Meet with the hyperlink. I guess it wasn't hyperlinked in the invitation like it normally is. So I just get around it by copying and pasting into a browser, and it works fine. I guess that's not an option, possibly, for David.
Yeah, I'm on the phone, Your Honor. We're having a little trouble with that. I don't know if it could be resent so we could.
Yeah, I think I can do that. In fact, what I'll probably do, yeah, it'll take me a moment.
Okay. Well, I'll get out of this one then.
And did you copy and then just paste that link into a browser? I had to do that as well. Unfortunately, the hyperlink wasn't activated or set up on it.
Okay. Let's see.
If you've got Google Chrome or Internet, what is it called now? Edge or something, Microsoft Edge. You've got a Windows computer.
Yes. Okay. I'll go to Edge.
Right, and then once that's open, at the very top, it should just give you like a whole thing of it. You can just copy and paste that, hit enter, and that should work. Although Edge isn't set up, this is a Google product, and Edge is Microsoft, so I don't know how well they'll play with each other.
Okay. Let's try that. Okay. Here we go. Maybe this will get us joined. So, okay, it's asking for my name. So, okay. Okay, give me just a moment. I may, oh, wait a second. And I'll just say ask to join. David. Asking to be let in. Okay. Okay. Now, let me turn this off. Okay, now we've got to get the camera going. And when I click the camera, nothing is happening. Can you both hear me?
Yeah, I can hear you loud and clear.
Well, that's better than nothing. I don't know why the camera isn't working.
You may have to go to settings. So you click on that little dot under more options. See those?
Yeah.
And then go into settings. It's the first one up. The first one up.
Let's see. Change layout. Oh, settings here at the bottom.
Yeah. Then you go to video, and then it'll tell you what camera it's trying to use. And you may have to change it or mess around with that.
I see. So we've got the right camera. It says camera failed. Huh.
Oh, well, that's not good. Okay.
But the light is on my camera like it normally is when it's working. That's strange. I was doing this yesterday with a case, and I just had to start over again and log back in, and then the camera worked fine. So maybe I could do that if you have a minute, everyone.
Sure, that's, yeah, let's try that. And then if not, excuse me, is Mr. El-Hewie with you?
He is.
Yes.
Okay. All right. Well, yeah, let's try to have you restart it and see if that works, since that seemed to fix the problem yesterday. If not, then we'll see what we need to do to address it.
All right, so let me try this again. Okay, now, how did we get...
Turn this on and off.
What's that?
Turn the camera on and off.
Yeah, this means it's on.
Turn it off and turn it on again. Yes, disconnected and connected.
Okay.
Connected again.
So how did we get back to that? Remind me. What did you...
Concept.
Welcome to Google Meet. Enter the meeting pin followed by the pound key.
Oh, I can see you now.
Okay, so I see you, Keith. Don't see the judge, but we've got our camera working. Oh, there we go.
He said he was going to be. Oh, there. Okay.
Yep.
All right.
I'm here, just waiting.
Well,
All right, welcome. Mr. Holdsworth, do you have everybody here that needs to be here for petitioner?
yes.
Okay. Oh, excuse me. And Mr. Orgel, do you have everybody here that needs to be here?
Yes, just me.
Okay, great. And then welcome to the petitioner, Mr. El-Hewie.
Thank you.
Okay, so let's, before we begin the hearing, before we begin the recording portion of it, let's go over just a few things, and then I will start the recording, and we'll begin the formal part of the hearing in the case. Basically, there's just two things to address with this technology. The first is, because it's remote hearing, somebody could get disconnected. If that happens, just use the same link to rejoin, and then we will wait for you. Or if for some reason you can't, you can use the phone number to call in, like Mr. Holdsworth had done earlier. The other thing is, if there's a lot of background noise, I will mute your microphone so that I can hear and we can have a clear record. and so the other parties can hear as well. If I do that, I can't unmute you. It's something that you have to do yourself. There's two ways that I'm aware of to do that. The first is to hit Control D, at least on a Windows computer. The other option is down at the bottom of the screen, there's a row of icons. I probably don't need to go through this. I think you both have heard this before, but you can manually click on the microphone icon, which on my computer is the last circle at the bottom of the screen in the middle section. But with that, let's begin the hearing and begin the recording. Okay, the recording has begun. My name is Brian Stewart. I'm the administrative law judge for the hearing today. We're here for case number 22-0395, Mohammed Fahim El-Hewie versus Walmart Associates Inc. and or AIU Insurance Company. There's also New Hampshire Insurance Company listed. And are both of those insurers parties to this case?
My understanding is it was AI. Typically, those are the excess carriers for Walmart. Walmart is mostly, I believe, self-insured on this one, so I believe it's AIU is the correct insurance carrier on that one for the excess. But sometimes they get added for both of them. That's always the issue.
Okay, so should New Hampshire be dismissed or removed, or is it?
I have AIU, so New Hampshire I think would be dismissed. Yes.
Okay. And Mr. Holdsworth, do you have any objection, any issue with New Hampshire not being named, essentially being dismissed?
No problem with that.
All right, made a note of that. Today is April 5th, 2023. It's a little after 3 p.m. Counsel, if you'd make your appearances at this time.
David Holdsworth for the petitioner, Mr. El-Hewie.
Thank you.
Keith Orville for the respondents, Walmart Inc. and AIU Insurance Co.
Okay, thank you. All right. So let's go over the medical record exhibit, and then the issues, and then any stipulations that the parties have. So first off, I've received the medical record exhibit, and let's see, I received that on March 22nd. And it looks like it is 103 pages, including the index. And then I also received, it looks like, an additional medical record just today. It's a musculoskeletal office visit note performed by Michael Ramish. So I'm not sure if that's supposed to be a part of it, and I don't have a note as to who sent that in. So I'll just ask you, Mr. Holdsworth, first of all, is there anything, is that medical record, is that from petitioner, does that need to be added to it? And then is there anything else, any other changes that need to be made?
Yes, Your Honor, I did send that in. It was attached to the application for hearing. It's a 2-page record, but as Mr. Orgel and I discussed this yesterday via email, we thought, at least I thought, and I think he agrees, that it should come in as part of the medical records exhibit itself. And so it just makes sense to put it at the end of the rest of the medical records exhibit. doesn't fit there chronologically, but there's only 2 pages, and I mean, we're happy to put it wherever you think it might better fit, but that's the reason why we're submitting it as part of the medical records exhibit. Then I have one other issue with the medical records exhibit, and that is I've noticed as I was going through the medical records exhibit that there was a visit that Mr. El-Hewie had to Intermountain WorkMed on February 7th. For some reason, and I just picked up on this today actually, for some reason we don't have that actual visit note from Intermountain WorkMed. We have a January 19th visit note and a January 26th visit note, but February 7th, would have been 2022, 2022. We don't have that in the Intermountain WorkMed records. I don't know why that is. It's referred to in some of the other doctors' reports. For example, just so you know, on page 15, this is the record of Dr. Ring. He refers to this visit on February 7th, and then Dr. Gendy, one of the IME docs, refers to it at page 33. So I don't know where that is, but I would suggest, if we see if we can try and get it, because it exists somewhere. It's just not with the Intermountain WorkMed pages 8 through 13.
Okay. Sounds good. It sounds like it should probably come in as well. Are there any other changes to make? Any any objections to the medical record exhibit being admitted with the additional changes that you've identified?
No.
Okay. All right. And Mr. Orville, how about you? Do you have any objection to that February 7th medical record coming in?
No, I'm not sure why it's not in there. It looks like we did request all the records from Intermountain back in July of last year. Just looking through my file, not sure why that's not in there. I don't see it in the actual records generated either, so that's a little strange. Yeah, I have no objection to trying to get that record. I just don't know why it's not in there, and no objection to adding the Dr. Rainish report that was attached to the application for hearing as a formal exhibit for the actual medical record exhibit.
Okay. All right. And with the Dr. Rainish note, let's see. Are there other medical records from Dr. Rainish that are already in there, or is this it for him?
There was only one visit. It's not part of another part of the exhibit, so it's coming in new, so to speak. It's referred to by some of the other doctors. But...
Okay. All right. So let's do this. So I'm going to mark that exhibit as J1, and I'll admit it. At this time, just admitted, but in light or with recognition that that additional record will be coming in if it's available. That February 7th, 2022 visit note. Who will be in charge of getting that? I know usually it's respondents, and I know that you've requested that. Do you want to continue with that? Is it easier for you to get it, Mr. Holdsworth? I assume respondents, it'll be easier for them to get it.
Probably. I think maybe just a follow-up letter saying we got the two notes, but there's a third visit, and could you track that down and send it in, something like that. But it
Okay.
would be best coming from respondents, I think.
Okay. So can you handle that, Mr. Orgel, and then add that, and then the Dr. Ramish medical record as well. And the Dr. Ramish record can be added just to the end of medical record exhibit. And is 30 days, usually I give between 14 and 30 days. I'm not sure that 14 days is enough time to get that other record, but
I think 30 days should be sufficient. I think we already have a release. It looks like we sent a release with the original request. So assuming that's we don't need to get a new one, we should be able to send that out pretty quickly.
okay. All right, thank you. All right, the next thing is there anything that parties can stipulate to today?
We discussed it, but I believe the TCD rate is the max rate of 1,038 a week. We had discussed that before the hearing. I'm not sure if we haven't really come up with an average of the wage, but we know the TCD rate is the max rate.
Okay, Mr. Holdsworth, do you agree with that?
Yes.
Okay. Anything else that the parties can stipulate to?
We discussed this as well, but there's a benefit sheet that I had sent over in an email also right around when we got this medical record. Just shows what respondents have already paid in the claim. I thought that would be a helpful reference point because this has been an admitted claim for a certain period, and respondents did pay TTD and medical benefits, and that reflects it on that. So I thought that would be a helpful document to include and ask David about it as well.
And no objection to that.
Okay. All right, so I'm going to let me make sure. Did you say that you had sent that in to the case filing as well?
Yeah, it was right after that. It was like that 1:30. It's about a half an hour ago.
All right, I do see that. It looks like it's 7 pages.
Yes.
Okay. I'm going to mark this as, let me see here. Okay, I'm going to mark this as Exhibit R1. And that is admitted. All right, anything else that the parties can stipulate to today? Or anything else that needs to be addressed before opening statements?
I don't think so.
Okay. All right, Mr. Holdsworth, the time is yours if you'd like to make an opening statement. Oh, I'm sorry. I kind of jumped ahead. I wanted to go over the claims and then the defenses briefly. Okay. So based on the pretrial disclosures, looks like historical medical expenses and recommended medical care are both being claimed. Is that correct, Mr. Holdsworth?
It is.
Okay. And is there, it sounds like there have been some medical expenses that have been paid already. Do you have any more detail as far as the historical medical expenses? Is there a cutoff date where you're, after that date, that you're seeking expenses, or and if you don't, that's fine. I know not every judge goes into that much detail, but
we think the carrier did pay everything historically. We need to review that benefits log a little bit more carefully, but
okay.
we're not aware of anything that is getting billed to Mr. El-Hewie historically. I mean, there would have been treatment continue, but it was like physical therapy, but that was not approved, so he just didn't get more physical therapy.
Okay. All right. And then temporary total disability compensation for various missed days in November and December of 2021, and then from December 22nd of 2021 to August 1st of 2022. Is that still accurate?
Yes, we can refine that a bit. I've determined from Mr. El-Hewie that there were really no days missed through November and December. He was paid temporary total until May 24th of 2022, and that's when it was discontinued. He became reemployed, the different employer, on August 1st, so there's still a claim for TTD from May 25th, 2022 through July 31st, I guess it would be, of 2022. So about 9 weeks.
Okay.
Well, maybe 11 or 12 weeks, but during that time frame.
Okay. So, all right. So now, the claim has been narrowed to for TTD from May 25th of 22 to July 31st of 22. Is that correct?
Correct.
Okay. All right. And then permanent partial disability compensation was claimed, but it said pending medical stability. His petitioner reached medical stability, and has an impairment rating been provided yet?
No and no. So that claim's premature at this point. We don't yet have a maximum medical improvement, because we have a dispute about medical causation and medical treatment.
Okay. All right. And then, let's see, travel expenses were also claimed. Is that still accurate?
Correct. Yeah.
Okay. All right. And then, Mr. Orville, I don't have the. Let me pull that up. So it looks like the two claims the two defenses are that petitioner's employment was terminated for cause, and so he's not entitled to TTD after that date, and that also petitioner can't meet the higher legal standard under Allen, legal causation standard. Are those both accurate?
We're going to withdraw the termination for cause issue. That we just decided not to go forward on that. But the Allen defense, if applicable, we would argue would be met here.
Okay. All right. Thank you. Hey, Mr. Holdsworth, if you'd like to make an opening statement, do so now.
Thank you, Your Honor. Mr. El-Hewie, it may be obvious at this point, but was a truck driver, over-the-road truck driver for Walmart. Had been working a few years for Walmart at the time of the injury. There'll be testimony about the injuries, the mechanism of injuries, what he did in basically cranking the landing gear of trailers up and down multiple times, several times during each work week, and then in particular what happened in early November 2021 that brings us here today. The parties have a fundamental dispute about medical causation for the reasons of the Allen case and Allen test and a number of other reasons. And I suspect this is the type of dispute that will have to be referred to a medical panel. We've got doctors lined up on both sides of that medical causation controversy, which typically means the case goes to a medical panel for at least a report, if not resolution. But we'll endeavor today to explain the mechanism of injury, how it satisfies Allen, and therefore qualifies Mr. El-Hewie for the benefits he is seeking. Thank you.
Yeah, thank you. And Mr. Orville.
Not too much to add to that. Respondents, as Mr. Holdsworth indicated, have actually two different reports. One is a medical report from Dr. Ring, just a records review of the claim, where he disputes the medical causation element of it, and also gives an overview of some of the pre-existing degenerative conditions in both wrists. And then Dr. George Gendy was the IME, that was in March of 2022. That essentially has a similar opinion to Dr. Ring. So again, respondents are disputing medical causation as well as asserting the Allen defense due to the pre-existing conditions in both wrists.
Okay, thank you. Give me just a moment. Okay, Mr. Holdsworth, if you'd like to call your first witness, you can do so now.
Yes, we'll call Mr. El-Hewie. I'll move the computer a little closer to him, and hopefully you'll be able to hear him okay. He does have a bit of an accent, but you should be able to understand him just fine.
Okay. All right. And Mr. El-Hewie, I will need to swear you in. Okay. And are you able to raise your right arm? Okay. Oh, excuse me. Do you solemnly swear that the evidence that you shall give in this issue shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
All right. Mr. El-Hewie, well, let's see, did we lose the judge?
Don't see him anymore. Uh-oh.
Yes, I am here. Sorry,
Okay.
I clicked on the microphone and it clicked on the camera as well.
Oh.
I am here. So.
Okay. All right. Mr. El-Hewie, could you tell us when you began working for Walmart?
I started Walmart in August 2019.
Is that loud enough? Okay. And what was your position with Walmart?
I was a professional truck driver with 5 years prior experience in over-the-road driving. That means that Walmart cannot hire me unless I have verifiable, uninterrupted, continuous professional driving of 40-ton equipments like a tractor trailer all over the 48 states of the United States with a clean driving record, which means no violations. And then I have to pass the physical test, which means you cannot have diabetes, epilepsy, or any illness that interferes with your ability to operate heavy equipment.
So you had a CDL?
Yeah, I have a CDL and I have a medical record and you have a drug clearance record that prove that you are qualified for this, a job that is regulated by the federal government.
And did you work full-time for Walmart?
Yes, I work full time. It is really not full time. It is the whole time. which means you stay in the truck 5 days, you don't go home, and you go home 2 days a week.
And were you driving all over the United States?
You're driving the 11 western states, which means that from I-25, you drive in California, Oregon, Mexico, Washington, Nevada, Arizona, New Mexico, Colorado, Idaho, Montana, and Wyoming. Those are the 11 states you have to drive through.
And were you delivering to products to Walmart retail stores or distribution centers or what?
It is two parts. You deliver from the shipper or the retailer or the port of entry that comes from overseas to the distribution center. This is one part. The other part from the distribution center to the stores of Walmart in the 11 states.
All right. And you're driving a tractor trailer?
Correct.
One trailer or more than one?
It is a very, very special combination. The tractor, which is called power industrial power unit, that is weighs about 26,000 pounds, and the trailer that is 53 feet long. The entire combination is 75 feet long. The entire combination weighs maximum 80,000 pounds.
All right. So let's go to the type of work that you had to do. We've talked about in the application for hearing this cranking of landing gear. Tell us what that means and how often you had to do it and under what circumstances.
When you drive a combination means a tractor that is power unit and a trailer that is a cargo unit. The first physical labor that you have to do is you have to couple.
Couple, did you say?
Couple, correct.
Okay.
Couple means link the power unit to the cargo unit. The coupling includes connecting and disconnecting 3 cables, 2 air cables and 1 electrical cables. So you have to connect the power cable, the brake line, the red line,
Sure.
which we call it the brake line, the blue line, that's the air line, and you connect the electric line. This is the first physical contact. Number 2, you have to raise or lower the landing gear of the cargo unit so it can be towed by the power unit.
Let's just call it the trailer.
The trailer, yes.
All right.
You have to raise the landing gear of the trailer so it can be pulled by the tractor.
And how do you raise or lower the landing gear?
The landing gear have 2 settings, low speed or high speed, or low gear or high gear. It depends on the weight of the cargo. If the cargo is very heavy, you cannot use the high gear, you have to use the low gear, which means it will take you up to 100 or 200 cranks to get the landing gear up. If the weight is light, you can make it in 26 cranks, which means you crank it up.
And let's talk about that. Are you doing, the driver, are you doing the actual physical cranking?
There is no other alternative. The driver have to do everything. The driver have to crank it. There is no pneumatic motor. There is no electric motor. It is a manual job, which means you have to stretch the handle, the cranking handle, to connect it to the rotating axle of the gear, and you have to crank it. One hand or 2 hands depend on how hard, how resisting the cranking handle is. The resistance is determined by the weight of the cargo, the weather. If the handle is frozen, you have to go back to get a hammer and hammer the entire component to break the ice inside.
Okay.
If it is rusted, you have to do the same thing, hammer it. You cannot oil it. You cannot put oil because the oil requires an oil gun. It have to go through a certain nozzle, and the grease have to go inside. That is the shop problem.
Okay. I'll interrupt you as you're going through this. In a typical run, let's say you're going to Las Vegas, for example, or Denver, whatever. how time during that run are you doing this picking up down?
Unit 1 is 5 miles, which handy. So one day, when you pull up the cargo, the trailer from the distribution center, from one point, when you reach the end point, you have to drop the trailer. So when you drop the trailer and hook the trailer, that is twice. That's 2 jobs. Then at the end, you have to do it twice again. So minimum cranking up and cranking down in a single stretch of 400 miles, that's twice a day. But that can go up to 6 times if you are unlucky and you have to move another trailer from the end destination because you don't have enough room. It can even go up to 8 times in one day if you have to have multiple stops, which means multiple stops means you travel from, for example, Denver, you have 2 stops in the mountains between Denver to Utah. You stop at Vail, you stop, for example, at Rifle City, you deliver to one of these stores. Then now we have 2 stops between the beginning and the end.
Okay.
So that multiply these 4 stops by 2 each time. It will give you about 8 times a day of cranking up and down the trailer.
So in a typical week, a 5-day week, could you give us some sense of, on average, how many?
On average, 5 days you multiply it by 4, that will be the minimum. 5 by 4, that will be 20 times. The maximum will be 5 by 8, which means 40 times. So you're cranking up and down about between 20 and 40 times a week. This is only the cranking. Remember, the cranking you connect to the 3 hoses.
Right.
We call it gland handle, and you connect to them. The hoses are not a simple thing. You have to hold the hose handle and twist it down. If it doesn't go with you, you have to use a hammer on it.
All right.
So each time you crank, you have to connect and disconnect to the air lines and the electric lines.
When you are cranking, are you standing up straight? Are you crouching? Are you bending? Are you squatting? What typically do you have?
It depends on the arrangement of the trailers. If your trailer is next to another trailer, every company tries to save the space on the ground. So they have to have the trailer. You walk about between 1 foot and 2 feet between the trailers. So if you are lucky, you have no trailer next to yours, that is a good day for you. If you are not lucky, you will have to walk in a narrow aisle between the 2 trailers, and sometimes you have to walk with your shoulder. Then you might not be able to use 2 hands. You might have to use only 1 hand. That is where the problem happens, when you have to use 1 hand to crank.
We'll talk about what happened there in just a moment. So, did you have a home base or home location?
The domicile is Grantsville, Utah. That is the home base, the terminal.
Okay, let's call it the terminal. That's the distribution center in Grantsville?
Correct.
All right. Now, besides cranking and attaching the hoses, are there other, besides driving and doing the pre-trip and post-trip inspection, are there other physical, exertional activities that a driver has to engage in?
The definition of a professional driver is a very specific definition. That is, the federal government and the state recognize you as a professional, which means you are responsible for the combination of the tractor and the trailer. You have to make sure the brakes are working. If the brakes are frozen, you have to lay down on your back. You crawl under the truck on your back and hammer every brake drum with a hammer. You are responsible for that. You are not going to get a mechanic to fix the brakes of the trailer for you. How many brakes you have? On the tandem, you have 4 wheels. That means 4 drums. On the tractor, you have 4 wheels on the drive. On the steer, you have 2 wheels. So you have total 10 wheels, 18 tires. This is number 1 job. Number 2 job, you have to make sure the tires are inflated, which means you have to have a hammer. The hammer is a heavy hammer. You slam the tire with it, and you hear the percussion. Percussion is like when the doctor tries to see if you have pneumonia or not. So you have to hit all the hammer with you, all the tire with your hammer to make sure it is inflated properly. If it is not inflated, you have to call for that. Then you have a mandatory every 1.5 hours or 100 miles. You have to stop and do the inspection with the hammer with the equipment. So you go around the truck, what we call it 360. 360 means this is the truck. 360, you go around the truck to make sure the equipment with your tools, with your hammer, to make sure nothing in the truck is leaking, nothing is broke,
Sure.
nothing is loose. Every truck driver will tell you the three things: broken or not, loose or not, leaking or not. That is the job every 1.5 hour responsibility. If the police officer,
Hold on, let me, we don't need that much detail. What about if you are in inclement weather? Do you have to do anything there with respect to being able to drive?
to chain a truck on a slope in the snow, you get paid for that about $60. How fast can you do it? It can go from 1 hour to 2 hours depending on how cold the weather is, if it is dirty, if it is wet, if it is dark.
So does the driver have to do the chaining up?
Yes, the driver have to chain minimum 4 wheels, but most of the time you have to chain 6 wheels in order to chain and unchain, which means you chain when there is enough snow that covers the asphalt, and when you get to the dry area, you remove the chains. If you have to run again into the snow, you have to put the chains.
Okay.
So if you cross from Denver on I-70 to come to Utah, you might have to change going to Lincoln Tunnel. You might have to change again in Vail, and you might have to, each time you have to remove the chains.
Mm-hmm.
Yes.
And you do that by hand?
Well, you have to do it by hand. You have to crawl under the wheels. You have to change the gloves, a minimum of 3 pair gloves, and every time you might have to go back to the truck and get your shoes off and dry your sacks. You have to have 2 or 3 pairs of sacks because you get wet.
Sure.
You have to have a certain suit, like a rubber suit, to be able to crawl under, because when you put the chains on the top, the other parts of the chains, you have to go under and grab them from the other and connect them.
All right.
After you connect them, you have to tighten them.
When you were doing the driving for Walmart that you've been talking about, are you by yourself or are you with a partner in your truck?
It is a solo job.
Solo. All right. So all of this cranking and chaining, and that's you're doing that by yourself.
Yes, a driver is called the power of one. A power of one means the driver has to make all the decisions: the driving, the mechanical, the maintenance, the responsibility,
Okay.
the federal and the state.
Now, could you tell us what happened on November 3rd of 2021? That's been alleged in the application for hearing.
On November 3rd, I think at 12 o'clock, which I start at 5 o'clock in the morning. At 12 o'clock, when I came back to pull the second load, the trailer was brand new. And when it is brand new, sometimes the gears are not lubricated or sharp. And the trailer was loaded. And it was in Grantsville, Utah. So when I went to the trailer, the cranking handle looked like it is not like an S shape. It is like something like 90-degree angle and another 90-degree angle. So the cranking handle was in the slot. The slot means it is what you call it in the holster. Like when you put a gun in a holster. So the cranking handle in the holster. Here is the problem. When I try, usually when you can get it out of the holster with one hand. I put it with one hand, it did not move at all. So I put it with 2 hands, it did not move. It was stuck down in the groove. The groove is like 1 inch wide, a slot, and the handle is in it, holding. So I went back again. I brought a hammer to hit it from the bottom. It did not move.
Hit the handle?
Handle, yeah, to get it out so I can use it. It did not move. I went back. I get a chain, the snow chains. I put it under the hammer, the handle, and pull it up. It did not move. Then I was able to fasten the chains and to the frame of the truck and under the hammer and put my entire weight on it. Once I put my weight on it, I have a bulge on my right hand.
You have a what?
A bulge.
A bulge? Okay.
A bulge on my underhand. The bulge look like that's exactly the way it bulges right here.
Right at the base of the thumb?
Under the thumb on the back of the wrist, you can see the bulges right here. Well, I thought this is a soft tissue bulge. We call it ganglion, which means when somebody hits you with anything, you have a swelling, come edema, and I put ice on it. I wrapped it very tight. I went back to the office. That was 12:50 in the morning, afternoon. The first one I met with Jana.
Hold on, we're going to get to that in a moment. But so you're trying to free this handle. Your Honor, if I could just have 10 seconds, let me move this phone out of the room so it doesn't keep ringing. Okay, so you're trying to free the handle. You're doing this kind of figuring out how to do it. Did you eventually free the handle?
I did free. Well, if I give up, if it didn't work, the next step was to call the office to tell them to send a mechanic with a crane or a forklift. A forklift will go under the handle and lift it up because it exceeded my ability to do it.
Sorry to interrupt, but we got to get these details. When you say you put your whole weight on trying to get the handle free, how much do you weigh?
I weigh at that time about 240 pounds.
And were you lifting?
Vertical lift up. From you have to get the handle up.
And what were you lifting with your right hand?
First, I lift with one hand. Then because the trailer was on my left hand. So usually you try to look around. Usually you don't fall. Try to lift with the left, it didn't work. The right didn't work. Then I start getting all my equipment, the hammer, the chains, a lever. I was able to get it with when it is free, the last one, I clicked it up, it did come up, but then you have the acute, the sudden, something jumping on the back of the hand.
On the back of your right hand.
The right hand, correct.
Can you give us some sense of how much you were exerting to try and get that hand, to jerk that handle free or get it to break free?
Well, I already went to progressively, one hand, two hand, three hand. Then when I realized that is going to be a big job, I might have to call the office. I have to spread my feet apart to have a stand where I cannot fall. But once I was able to get, the hand did not come out. The chain was under the hand. I was holding the chain, put it up suddenly. I got the handle out, but I also got my hand, strained in the process.
All right. Were you saying would you say you were using all of your strength?
Yeah, standing strength. I did not go, for example, for like a wrestler, try to wrestle, but I was shoulder strength, yes. Maximum shoulder strength, correct.
All right. Did you feel any pain in your right hand?
Well, that is the only time when the pain was a knife pain, a sharp pain in the back of the thumb and the wrist.
Did you hear any pop or anything, any sound?
When you get an acute pain, you try to survive the second and half second acute pain. You try to hold it tight until the pain goes away, and then you try to figure out what to do next. As soon as I was able to go through this about half second acute pain, I ran into the truck and I grabbed my bandage wrapped it. I usually wrap it from about 2 or 3 inches from the bottom up to under the knuckle around. It's very good.
Okay, and let's clarify something. You're wearing today. You're wearing these gloves on your hands.
Correct.
At the time,
Mr. Holter,
yes,
can I interrupt you?
please.
Can I have a petitioner, maybe if he can be a little bit closer to the microphone or speak a little bit louder?
Sure.
I can mostly hear him, but I'm having a little bit of difficulty. Okay, thank you.
So today you're wearing these gloves. My question is, at the time you were on November 3rd, 2021, when you're trying to get this handle free, were you wearing gloves at that time or just using your hands?
No, I got these gloves after the injury.
Okay.
Before the injury, I have stuff that you buy from Walmart, a bandage. You wrap your hands with. At that time, I think I do have that video that you put it in your chest. My hand was wrapped by bandage.
After the
During the process of pulling the handle, because 2 weeks before that, I was already have the chain issue. When you chain a truck,
okay, hold on. Let's finish up the handle, then we'll talk about the chaining.
Yes.
Okay, so after you noticed this pain and bulge in your right hand, you wrapped your right hand.
Correct.
And then I interrupted you. You said you went into the office to tell someone?
Correct.
And who did you tell?
The operation manager, that is my direct supervisor, her name is Jonna Crossley. Jonna Crossley sits in front of the office of the General Transportation Manager. She is my first contact.
Is it Jonna or Jana?
Jonna Crossley.
All right. What did you tell her?
She asked me, why you did not leave yet? It was 12:30 afternoon. So I showed her my hand. My hand was covered by grease and it was wrapped. Then I took the wrap out and showed her my hand. The swelling was there. She said, do you want to go to the doctor? Do you want to report? I said, no, truck drivers, we don't go to the doctor every time we have an injury. Just put an ice on it. I wrapped it. It will be okay tomorrow. After a week, Jana asked me the same question. I was already wrapping my hand. I answered her the same answer. It will be okay. It's getting better. Then the safety manager, Nick El-Hewie, saw me again after 3 weeks wrapping both hands, both wrists. Said, do you want to go to the doctor? I said, it's going to be okay. When you drive a truck, you get injured every day.
Did you eventually seek medical treatment?
I did not seek medical treatment until I wasn't able to open the door of my apartment.
All right. When was that?
That was exactly around January 1st, 2022.
All right. And we have the records as Intermountain Work Med. Is that where you first went for medical treatment?
Correct. Between January 1st to January 19th, I was in the process of seeking where to go. I was already fired from my job. I have a good time staying home. I needed to relax after 7 years of never coming home. So the first time when I tried to open the door with the key, I had a bulge in the hand. After I wrapped it, the pain did not go away. From 3 weeks or 2 weeks, I started finding out, looking at Google, find out where should I go.
Okay. Well, we'll talk about that in just a moment. Now, a few minutes ago, you mentioned that you had had an incident or a situation with chaining of the truck.
Correct.
By the way, as a driver, are you driving the same truck? Do you have a dedicated truck, or do you just drive whatever is available?
Well, you drive your own truck dedicated, but if your truck breaks down, you change the truck.
Sure.
For example, if your truck breaks down, you borrow another person's truck. The other person is be at home.
Sure.
The person at home for 2 days, I can take his truck if my truck is in the shop.
Okay. So, talk about this chaining. Was there an incident with chaining that caused a problem?
I have a run from Grantsville to Vernal, Colorado, that have to go through I-80 west, I-80 east, climbing on Barley Canyon and going to I-40 east to Vernal. When I got to Barley, 6 o'clock in the morning, there was a closure between a mandatory chaining process.
Okay.
All the trucks have to pull on the chaining area. All the trucks have to chain. You cannot climb the mountain without chaining. The chaining took me about 2 hours. Whenever you have mandatory chaining, you try to take as much time as possible, hoping that they will tell you you don't have to do it. In 2 hours, I was able to get the 6 wheels chained. I was able to get out when
And about when was this vis-a-vis the?
I think that was about October, between about 2 or 3 weeks before the injury.
So 2 or 3 weeks before November 3rd,
Correct.
2021.
Correct.
And that particular chaining situation at Parley is just outside of Salt Lake, I guess.
Correct. About 10 miles east
Okay.
of Salt Lake. Correct.
Did you have any problems, with that chaining?
Anytime you chain, you expect to be in the bed for 2 or 3 weeks, paining in your back, in your legs, and your arms, and you don't know what is going to happen to your body. Chaining is an acute process. You're sitting on driving a truck, and suddenly you have to come out of the truck to chain. Chaining is you have to crawl on the snow under the wheels, lift the chains, put them on every wheel. After you chain, you have to make sure they are secure. After you make sure they are secure, you have to stop every few miles to make sure that the chains are on the wheels.
All right. Okay. Now, just again, before we go to the medical records, we'll briefly go through those. But in November 2021, how old were you?
51.
51?
Sorry. I hope. I was 71.
All right.
Correct.
There's a big difference there. So, so you were 71.
Correct.
All right. And you mentioned in some of your testimony you'd been driving, professional truck driving for 7 years?
Correct.
So about 5 years or 4 years before Walmart?
Correct. I started driving a truck 2014 after I retired.
Okay. All right. And in your pre-retirement employment, were you a truck driver or something else?
Well,
I don't need to know exactly what it was, but were you?
I was a teacher. I was a doctor. I was an engineer. I was a self-employed. I did everything that has nothing to do with driving a truck.
Okay. All right. So let's move forward. You go to Intermountain. You determine that you're going to go to Intermountain WorkMed.
Yes.
And you have, how many visits do you have with, do you remember, with Intermountain WorkMed?
3 visits with orthopedic doctors. Yes, 3 visits exactly, and 1 visit with a hand surgeon.
And who was that?
The hand surgeon was Michael Ramish.
All right.
And the missing document that you are trying to find out, I have it on my computer. I have it on my hand.
Right, we have it also, but
Correct.
Did you see Dr. Ramish just the one time?
Correct.
All right. And then there also are records from Dr. Brian Mackey.
Correct. That is the last one.
This is the last physician that you saw?
Correct.
Okay. And how did you come about seeing him? Were you, in other words, did you choose him? Or were you told to go see him?
After Walmart refused to pay me money, I have no insurance, so I have to wait for the Medicare To be active, I have to pay for the Medicare. The Medicare started July 1st. Once I get my medical insurance, I went to the Family Jordan Clinic. That was the doctor, the primary physician. I told her I need to find somebody to treat my hand. I might need a surgery. She referred me to Dr. Brian Mackey because his father was a hand surgeon. And he was a famous hand surgeon. She said he is the best one to handle your case.
All right. We also have physical therapy records. Who recommended that you have physical therapy?
WorkMed recommended that from day one. That is January 19th. Dr. Leslie Rasner, she recommended me to have physical therapy, an MRI, and not to drive a truck.
All right. And so did you start the physical therapy soon thereafter?
Correct.
All right. And you just generally about how many visits did you have?
About eight visits.
All right. Okay. You've not had surgery on the right arm or hand or wrist?
No.
All right. Prior to the incidents of late October, early November 2021, were you having any pain or problems with your right hand in terms of being able to drive, function, that sort of thing?
When I was asked that question by every doctor, I said if there was any pain, it was a pain that you suffer as a truck driver. When you drive a truck, you drive 14 hours a day, you are in a roller coaster. So they tried to focus if I ever have pain on my right wrist. I said I might have pain, but there was no concern of that pain. It did not rise to the point where I cannot do my work. Today I cannot shave with the hand. I have to make sure the hand doesn't bend.
You're saying shave?
Shave,
Okay.
just shave. I cannot floss all the way inside my teeth without making sure that I can use certain tools to do the flossing. I cannot reach my back because of the injury. Before the injury, I did not have any awareness of any concerning pain.
All right. Now, the work comp carrier paid you some lost wages until, correct?
May 24th, correct.
Okay. And then that stopped.
Correct.
Then were you still unemployed at that time?
After May 24th, I really was not planning to go to work because I knew that's going to be a deadly situation to go back to work. Having a hand that is in a severe condition means that you can kill yourself driving a truck. Until the end of July, the the unemployment office of Utah, they got me in contact with CR England. They said they can have a job for you where you don't drive too much. You can sit a lot and you are going to drive less.
So did you go to work for CR England?
I went, yes. So they started me at orientation on the 26th of July, and I got my first truck on August 1st, correct.
So from May 24th until August 1st, were you working?
No.
All right. Okay, just a couple of other questions. We'll go through this quickly, but we need to just talk about mileage.
Correct.
So from from your residence to Intermountain WorkMed, about how many miles round trip is that?
14 miles both ways, and I gone there about 3 times.
14 miles one way.
Both ways.
So 14 miles round trip.
Correct.
All right. And then you had 2 MRIs.
Correct. 2 MRIs, that is 20 miles round trip, each one of them.
Okay. And you saw Dr. Ramish once.
About 14 miles around the trip, correct, once.
Then same question with respect to Dr. Gendy. Did you?
That is 7 miles one trip.
Okay. And then Dr. Mackey, what would
It
you
is,
estimate the
20,
miles?
20 miles around the trip, one time. Well, there is another, it has to be 2 times because I have to be referred to him. So Dr. Mackey and the family Jordan in the same city.
Okay, so you had the one visit with the Jordan family,
And one visit with Dr. Brian,
and that was about how much round trip each time?
20 miles.
All right. And then physical therapy, how far was it?
It is about 14 miles around the trip, about 8 times.
All right. Let's see if there's anything else I need to ask you about. So since Dr. Mackey, you saw Mackey in September of last year, have you treated with anyone for your right hand?
No, we have.
After Dr. Mackey.
There was the plan was clear. Dr. Mackey recommended either conservative surgery or radical surgery or medical. So I already know the plan, what the plan is. The problem was that, where do I get the money to take time off work?
Sure. If you undergo surgery, you'll be off for a period of time.
Surgery is out of the question now because I might lose everything. Surgery. Because I might be 1 year off, I might not be able to work at all. Conservative surgery, 6 months, which means conservative surgery is a simple surgery that can take away the pain. The way he explained to me.
But we don't need to get into that.
Okay.
That'll be in his records.
Okay.
Dr. Mackey was the last treating physician
Correct.
that you saw for your right hand.
Correct.
All right. Okay. Those are all the questions I have, Your Honor.
Okay, Mr. Orgel, do you have any questions for the witness?
I do. Just a couple of questions. I wanted to start with the mileage payments for going to medical appointments. You did receive a payment from Walmart, is that right?
I might did, but I really cannot be sure now. I think you will find that in the record because I send you the record. So if you have the record, you have the record, I think.
If they're right, I can share that really quick. We do have the records. I just want to quickly bring that up if that's okay. Remember how to do that.
Down at the bottom, there's a present now. It's an arrow in a box. The arrow's pointing up.
Yep, I've got it. I remember how to do it. Can you see that now? It's a couple of different. This is the first page of respondent supplemental. I believe it's marked as Exhibit R1. Do you see that now?
Is that question for me?
Yes. Did you see that? Did you see that on the screen?
Yes.
Okay. So this is a check, if I'm reading this right, mileage reimbursement to the order of Muhammad El-Hewie. So that's you, is that right?
What is the date on that? That is May 11th?
Of 2022, yes. May 11th.
Yes, I think that's correct. I see it, correct.
So it was 6250, is that right?
Correct.
And so at some point, presumably you submitted a mileage request to Walmart?
Sorry, that's a question?
So my understanding is then that you would have submitted some type of mileage request to Walmart.
I did. I think I did submit, and I think you have the record for it.
Right, and so to your knowledge, would this include all of the mileage up to May 11th, 2022 that you're claiming?
I think yes, that's correct. Correct.
And so the only appointment after that would be just the Dr. Mackey appointment. That would be the only one after May 11th, 2022.
Dr. Mackey, and the Jordan family.
there's at least just a couple of additional.
In addition, as Dr. Mackey and I have to pay like $300. I think you have the bill. I have to pay for Dr. Mackey and the family, the Jordan family for the doctor fees. Correct. I have to.
Just in terms of mileage, though. But see, it sounds like you would need mileage for the Dr. Mackey appointment and the other appointment
Correct.
You said, and then you paid out of pocket for some amount for those as well because those weren't authorized.
That's correct.
Okay. And then in terms of the left hand, I wanted to have a quick question about that. My understanding is you've injured you're claiming injury to both wrists. Is that correct?
The degree is different. The right wrist has a collapse. A collapse, which means the bones are totally disorganized. So the right wrist is totally dysfunctional at certain actions. You cannot do a torque. You cannot spin things with the right hand. The right hand can pull and push. You can pull and push, but you cannot do any torquing with it. The left hand did not collapse yet, but if I keep doing the same activity, collapse happens whenever the ligaments that hold the bone together is torn, the bones are scattered in the hand. You have a wrist instability. The right hand has a wrist instability, which means you have to have some way of fixing it.
And so my question is, at this point, are you requesting any additional treatment for the left wrist at all, or is this entirely about the right wrist?
The left wrist have to be treated according to Dr. Mackey. Brian, he wants to do surgery on the left also, but he has a priority. He wants first to take care of the right, and the left is injured as well, because now we are not using the right hand. So what are you going to use? You have to going to use the left hand. The left hand is getting traumatized every day.
Okay, so there's not a specific injury to the left wrist, unlike the right where you have this specific incident. The left wrist is, I've been overusing it because I'm not using the right.
No, the left wrist have two specific injury. What you call it, the first carpal and the wrist have to be replaced because that joint between the thumb and the wrist, the carpus, is totally, this joint has a problem. The other problem is that the cartilage is lost of the hand. It's very thin.
No, I understand there's underlying pathology there. My question was in terms of an injury. There's no specific injury that you can point to for the left wrist.
The left hand has a very specific single injury between the thumb and the wrist. The joint have to be gone.
I think you're not understanding his question. I think he's asking.
Right, so if I can rephrase it. So, for example, when we talk about dates of injury and when something is harmed or injured, in the right wrist, you testified that there was a specific incident on November 3rd, 2021, where you were doing this crank and then it starts hurting, right? That's a specific date of the injury, a specific incident. Does that make sense?
A specific date of injury, that is the acute part of it. But there is another chronic injury that takes months. So your point of view that you think an injury is a date, like you put a single minute, a single day, a single year, this is called an acute injury. But a chronic injury takes a while to develop. An acute injury. You cannot pinpoint the exact date and the exact minute. So the left hand does have a specific injury that's chronic.
It's a chronic injury that's developed, my understanding, is over time due to potentially overuse.
Well, once you get the X-ray to any doctor, the doctor will immediately tell you these joints have to be replaced. So that is why it is called an injury.
Right. I understand that there's medical terminology and legal terminology. It does get confusing. The first date that you specifically reported that you had pain in your left wrist. My understanding is that would be the February 7th, 2022 Intermountain record. Is that correct?
That is very correct. That is correct. Yes, absolutely.
Okay, so and when you initially saw Intermountain in those first two visits in January, it was all about the right wrist.
Well, when I knew that when I was told I have a collapsed hand, I was in a state of shock. I never thought I would be a candidate for a surgery. I never thought I will have a surgery in my life. So once they told me I have a collapsed right wrist, I started thinking about my left wrist. I said maybe my left wrist also is collapsed. So because I have pain also in my left wrist, not as serious as the right, I went to the doctor again. I told him I needed to make sure that the left wrist and the hand don't have to go through surgery. That is when I went to the doctor on February 7th. That is correct.
Okay, and then you get the MRI a couple of days later of the left wrist.
Correct.
Okay. That's actually all the questions I've got. Thank you.
You're welcome.
Okay, Mr. Holdsworth, do you have anything on redirect?
I do not.
Okay. All right. Thank you, Mr. El-Hewie. I think that is all the testimony that we need at this point. Mr. Holdsworth, do you have any other witnesses to call or any other evidence to present?
No other witnesses, no other evidence.
Okay. And Mr. Orgel, do you have any witnesses to call or any other evidence to present?
No, none.
Okay. All right.
Can I make a point?
Mr. Holdsworth, let me ask you a question, just to make sure that I'm clear. So is it both the right and the left wrists that are their claims are being claimed, or is it just the right?
It is both.
Okay.
The application for hearing, I think, just referred to the right, but as the case has developed, it's become clear that there's also an allegation that the problems with the left wrist are work-related. So it's both right and left.
Okay. And then as far as the I think that this is a repetitive trauma claim, and it was culminated on November 3rd. When is the beginning date of the repetitive trauma?
Well, the cranking of the landing gear was started really when you started working at Walmart. That is, with respect to the Walmart repetitive trauma, right?
The specific answer for that is that Walmart has a unique nature. In Walmart, you work in the frozen states, which means the western mountains on the Rockies, and you deliver on the local state in these frozen states, and you have a very specific job, that's the fleet job. A fleet means you deliver from Walmart to Walmart. So your containers are heavy. So if you go before Walmart, you cannot have any feature of the chronic injury because there was no frequent cranking. Before Walmart, I don't have to do cranking any at all.
And you started with Walmart in
August 2019, correct?
August 2019. We'll use that as the beginning of the repetitive cumulative trauma.
Okay. And I wanted to thank you. I assumed that was the case, but I didn't want to assume it. So.
Sure.
Yeah, if okay. All right, Mr. Holdsworth, the time is yours if you'd like to make a closing argument.
Well, thank you, Your Honor. I'd like to briefly go through the medical records and highlight what I think are the critical entries from petitioner's point of view.
Mr. Holdsworth,
Please.
I'm sorry. Can we take, before you do that, can we take a brief recess?
Certainly.
Maybe 2 minutes, unless anybody needs longer. I have an urgent message that I need to address, and so
No
if
problem.
that's okay, we'll take about 2 minutes. I'm going to, so please make sure you mute your microphone. I'm going to leave the recording going, so if there's anything that needs to be, if you need to discuss anything, we don't want it picked up on the record. So we'll be back in about 2 minutes.
Sounds good. Okay. Feel free to walk around. Just watch out for that corner.
Yeah, I appreciate that. Normally I wouldn't take a break in a hearing for that, but it seemed urgent from one of the clerks. So, all right, Mr. Holdsworth, you can proceed with your closing argument.
Thanks, Your Honor. Like I mentioned, what I like to do in these closings is just highlight the medical records that support the petitioner's position, realizing that we have a dispute about medical causation. But first of all, is Alan met here? Well, that depends on how unusual or extraordinary is defined. Here we have hand cranking that happens very frequently during a week at least, and several times a day, so many times during the week, in all kinds of weather. Sometimes it's easy, sometimes it's difficult. And on this particular occasion, November 3rd, 2021, it was very, very difficult, and that's not the type of thing that you normally run into in everyday life. I mean, yeah, we may have to change a tire that goes flat once a year, or we may have to crank an RV up and down to get on the back of our pickup trucks, but that's usually not something that involves thousands and thousands of pounds of weight and a lot of using your entire strength to break a handle loose and then to crank with. So it's unusual in its nature and in its frequency, and it's extraordinary given the amount of exertion involved and how frequently it has to happen, as well as chaining up. These are big rigs, 18 tires, and you've got to get underneath and contort and be in awkward positions in the cold, on the freeway, side of the freeway, on the asphalt, and it's an unusual and extraordinary exertion from a petitioner's point of view. So we think Alan is satisfied. After the November 3rd, 2021 injury, it's normal, I think, for truck drivers, it sounds like, to think, oh, this will get better, or it'll reduce in pain, but that didn't happen. The pain didn't subside, the loss of functionality didn't improve, and so eventually Mr. El-Hewie sought medical treatment. First visit we have is on January 19th, 2022. That's at page 8 of the medical records exhibit. And the mechanism of injury is described as, quote, while cranking handle of a loaded trailer, the gears of the cranking handle missed or jammed, causing severe pain at right wrist under the thumb, followed by swelling and stiffness and pain, end quote. Note on page 9, the cause of the problem is related to work activities. That same sentiment is expressed in the next visit on January 26th. That's starting at page 11. And then we don't have that visit on February 7th, but if you go to page 33, this is in the Gendy report, Dr. Gendy report, and there's a summary of that February 7th, 2022 visit with Intermountain. And Dr. Gendy writes, and I don't know if this is verbatim or if this is just a summary, but hands and wrists are used in cranking the handle of the landing gear on commercial trailers. A stuck, rusted, or twisted part caused an acute injury to the right hand. That's Dr. Watson of Intermountain, but it shows up in the Gendy report. That's the missing February 7th report that I'm sure we can get our hands on, or at least respondent can try his very best. Okay, so we have the 3 visits with Intermountain. Then he is referred to Dr. Ramish. And Dr. Ramish, in his report on February 2nd, I believe it is, let me find that. Says this in his report. This isn't yet in the medical records exhibit, but it will be. Sent from WorkMed with a diagnosis of traumatic rupture ligament of the wrist. Reports turning a heavy crank on a trailer, jamming the wrist, complains of wrist pain and swelling. Date of injury reported as November 3rd, 2021. Dr. Ramish is trying to figure out, and he says essentially this is an acute injury on a chronic background or underlying condition, I guess is a better way of putting it. But he says, but this industrial incident and injury severely exacerbated things where he had sudden onset of pain and swelling that is unrelenting. And that's on the, I believe, the second page of Dr. Ramish's 2-page report. That again is part of the application for hearing if you want to follow along. So that's Ramish's view. This is there was an underlying condition, but it was asymptomatic. But this was an acute, severe exacerbation of that, making it cause to become symptomatic. Okay, then we have Dr. Ring. Dr. Ring says, I don't believe in cumulative trauma injuries, and there's nothing industrial about this. I mean, you know, it's pretty blunt, his report. We disagree with it, petitioner does, but that's the Ring opinion. Dr. Gendy is kind of the same thing. This is all pre-existing, all degenerative, all age-related, arthritis. There's no industrial incident at all. So then we have the report of Dr. Mackey, and that is found at starting at page 58 in September. And Dr. Mackey writes, gradual onset over the past 12 months. That's at page 58. And then he also says he had initially an episode, there's a word missing, but in November and December when working on his truck, period, because that meant a punctuation, felt a strain on the wrist and is that pain or has that pain since then. and the conservative treatment hasn't really helped so far. So I think this is a typical type of dispute where one side says, oh no, yeah, there might have been an underlying pathology, but it became symptomatic because of an acute exacerbation caused by an unusual or extraordinary exertion. Allen is met, and we have the IME docs, or at least the record review doc, Dr. Ring, and then the IME, Dr. Gendy, coming to a different conclusion, saying there's nothing at all industrial about this. It's all degenerative. Why it became symptomatic on November 3rd, 2021, I don't know that they really address, but the typical type of fight between physicians that usually ends up in a referral to a medical panel, and neither side knows how the medical panel is going to view the evidence, but from petitioner's standpoint, here we have a clear industrial injury that satisfies the Allen test and is the cause of a very serious injury. It's going to has required medical treatment and will continue requiring medical treatment as recommended by Dr. Mackey, likely some level of surgery with time off, and at this stage of Mr. El-Hewie's career, could be career ending or could be career extending. We just don't quite yet know, but that's why we brought the claim, why Mr. El-Hewie has brought the claim, and we expect that the medical panel will look at all of the evidence and use their expertise in helping the parties resolve this fundamental dispute about medical causation. Thank you.
Okay, thank you, Mr. Holzer. All right, Mr. Orville. And Mr. Orville, your microphone is muted.
Sorry, so respondents have denied the claim for two bases. The first is the medical causation basis. We have two reports, one from Dr. Ring and one from Dr. Gendy. One's the IME with Dr. Gendy and one's the records review. Both have made it fairly clear that this is a pre-existing condition, that there's a scapholonate issue, deformity, that has a significant amount of arthritis and additional issues that's seen on the MRI. They're pretty clear and pretty persuasive that this is a pre-existing condition. And Dr. Ramish agrees. I think he calls it an acute on chronic type injury. The chronic there implies that there's some type of pre-existing injury to both the left and the right wrist. And so respondents would argue based on that the first step of Allen legal causation that respondents have the burden of is met, that there is a pre-existing condition, and that therefore that burden shifts to the claimant to show an unusual or extraordinary exertion. In this case, respondents would say this isn't unusual or extraordinary. We would analogize to, like Mr. Holdsworth said, an RV, a recreational RV. If you're using that type of thing in the mountains, you typically do have to crank it. If you're in snowy conditions or in difficult weather conditions, you do have to put, I've had to do this before, put down chains to be able to get it through the mountains. So that type of recreational activity does involve this type of cranking, sometimes continuously cranking activity. Additionally, those depending on the condition they could be in, can be just as difficult as a Walmart or any other kind of semi-truck trailer that you're using to crank. So respondents would say this is, again, a not unusual or extraordinary. Our basis is our argument is that this was just a typical work day, and there's nothing particularly unusual about this type of activity in terms of pushing down to get the handle in the right position, or to do the. I guess there's an allegation that the chains would have had caused some cause of the accident. So respondents say it not unusual or extraordinary and should be denied under Allen. And then in terms of medical causation, again, we have the MRI findings showing consistent degenerative arthritis conditions in both wrists. Dr. Ring clearly indicated that, and Dr. Gindi both indicated there was some scaphoulnate injury that was pre-existing, and that had caused degenerative arthritis in the left and the right wrist over time. And so ultimately, they both opined that this was not a work-related injury, and that the type of mechanism described here would not have caused the type of symptoms he's having. Rather, this is a degenerative condition that is getting worse over time due to claimant's age, and therefore that would not be work-related from a medical causation standpoint. So I agree with Mr. Holdsworth that this is likely that portion of it, if it gets to that point, would be resolved via an impartial medical panel who would be able to look between Dr. Gindi and Dr. Ring's opinions and the opinions of the treating providers that are saying this is work-related. So essentially, two-part denial. First part, we think that the legal causation is not met, and second part, medical causation would not be met, and request that the claim be denied.
Okay, Mr. Holdsworth, do you have anything on rebuttal?
Well, let me just finish by saying this. With respect to legal causation and the Allen test, I think what we have to look at here is not only the medical facts, but the employment facts. Here's a person who he's doing a rigorous job, but he's able to do it just fine, and he's not having pain in his wrists on a constant basis. He's chaining, he's cranking, he's driving just fine until this late October and early November 3rd, 2021 incident. Now the incident, the chaining and especially the cranking and the effort required to shake that handle loose, those are work related, no dispute about that. What is a dispute as well, was it extraordinary or unusual? Well, if I've got a 42,000 pound RV and I'm cranking it up and down 20 or 40 times a week, that's pretty unusual or extraordinary, it seems to me. That's why it's different than, your little pop-up trailer or your little trailer that you go camping up in the mountains with the family with. Maybe you have to crank it once or twice at the beginning and at the end of your trip. That's it, and it's not weighing 42,000 pounds. Well, here we've got loaded trailers that we're dealing with, and they're being traveled constantly, hundreds of miles every day, and in all kinds of weather. And when they become difficult to break free or use, you got to use all of your strength, and you've got to do this many times, perhaps during a week, and multiply that by week after week, month after month, and you get some sense of the frequency involved. It's not just a couple of times in the summer going up camping. It's just much more frequent and extreme than that. So we think the Allen test is satisfied. With respect to medical causation, under the Allen line of cases, even if you have a pre-existing condition, if something industrial lights it up, causes it to accelerate or aggravates it or exacerbates it, that's covered or should be covered. And so we think that's exactly what has happened here. Asymptomatic, even if it's degenerative or arthritic, no symptoms. It was fully functional. There wasn't a collapse. That's what happened, as we now know from the MRIs. After the injury, there was a serious, they call it a scapholunate advanced collapse, I think is the technical medical term for it. We think the evidence shows that that is work-related. And if it happened because there was some underlying condition, well, what caused it to become symptomatic? That's the industrial component, and that we believe satisfies medical causation. But I think we all agree this is headed for a medical panel, and the panel is going to have to sort all of these things out. And we are confident that they'll do their job very carefully, and we'll deal with the report when it comes out, if that's what Your Honor decides is appropriate, which we think is the appropriate way to adjudicate this controversy.
Okay, thank you. So what will happen, as you both know, I'll review all the evidence that's been presented thus far. Excuse me. And then I will decide whether I can send whether I can issue a final decision now, or if the case needs to be sent to a medical panel. Based on what I've heard today about the medical dispute, it seems much more likely that the case will be referred to a medical panel. So what will happen, assuming that that's the case, once I have the medical record exhibit, within about 60 days, I'll issue an interim order, and then I'll send a copy of that to the parties. I will then refer the case to the medical panel. I'll send it to them. I'll have specific questions that I have asked them about Mr. El-Hewie's condition. Mr. El-Hewie, they will schedule an appointment with you, and then once they do that, you'll need to appear for that. You'll need to participate in the appointment. If you don't, your case will likely be suspended or possibly dismissed. So please make sure that you do participate. They will send a report to me, and I'll send a copy of that to the parties, and then I'll look at all of the evidence once more and issue a final decision in the case. So that's essentially what will happen. Thank you again for your time. I hope everybody has a nice rest of your afternoon. And then, Mr. Orgo, please remember to get the updated medical record exhibit within 30 days.
And I actually emailed my paralegal Liz. So apparently there was an issue. The reason why we don't have those is that there was an issue with the release we got. And I think we just never got a corrected release. So we may be reaching out to Mr. Holdsworth to get a different kind of release that we can submit and get those records that way. I think that's why we didn't get that last one.
Okay. Sounds good. And if there is an issue, if you need more time than 30 days, please just let me know. Just send something in to case filing.
Okay. Thank you.
All right. Thank you. With that, we'll end the hearing and the recording, and everybody have a nice rest of your day.
Thank you.
Thank
All right,
you.
thank you. Have a good run.
Thanks.
Thank you.